Good day, everyone. This is my first video. I'll be discussing Title 8 of RPC Book 2, or Crimes Against Persons. So, I made these videos. It's gonna be helpful for my review kasi pagod na ako magbasa lang and makinig ng... Although the videos on YouTube are very helpful because I remember more, I retain more when I listen to it. So, I guess yung gumawa ng mga videos ng ganito, it's gonna be helpful for me. I hope it's going to be helpful for me to remember all of the lessons we covered in criminal law too. So as I said, I'm going to be discussing crimes against persons, but this is going to be just part one because as we all know, crimes against persons, it's a long discussion. And so this is going to be part one of the videos I'll be uploading. It's my first video, so please bear with me. Okay. So crimes against persons, it covers Article 246 to 2668. Chapter 1, Destruction of Life. Section 1, Parricide, Murder, and Homicide. The first article here is Parricide. So, penalty is reclusion perpetua. This is the provision. Any person who shall kill his father, mother, or child, whether legitimate or illegitimate, or his, wait, what's this? Oh, or his ascendants or descendants, or his spouse, shall be guilty of parricide and shall be punished by the penalty of reclusion perpetua to death. So these are the elements which we should always remember by heart. So a person is killed, that the deceased is killed by the accused, and that the deceased is the father, mother, or child, whether legitimate or illegitimate, or legitimate other descendant, or legitimate other descendant, or legitimate spouse of the accused. See, I underscored here na parang legitimate other descendants, legitimate other descendants, or legitimate spouse of the accused because the illegitimacy, it only applies to the father, the mother, or the child. So pag sinabi nating ascendant or descendant, it should be a legitimate relationship. Or the spouse, it should be legitimate. So kung kabit mo, it doesn't fall under this because it's a illegitimate relationship. So to further discuss, this is the problem. What if A, the illegitimate son of B, and out of years of neglect and anger, A killed B? So ito yung mga usual na anak na hindi hindi acknowledged and all. So what crime is committed? It is parricide because although it is based on a legitimate relationship, the exception, as I said a while ago, whether legitimate or illegitimate. So kahit na illegal na anak, si A, and illegal niyang, so basically, illegitimate siyang anak, hindi naman siya kinikilala ng tatay niya, the killing of his father, which is his illegitimate father, is still under parricide. And so he should be liable for this article and be punished with reclusion perpetua. Another case is in the same problem. So A, what if A killed C? So si C, tatay ni B. So, illegitimate niyang lolo. So, will it still be parricide? So, the answer in this case is no. The crime committed is murder or homicide, which will be discussed later kung saan siya nagpo-fall, as the case may be, and not parricide. The exception only applies to parents and children and do not include grandparents. So, as in this case, since yun na nga, yung lolo niya, hindi naman niya illegitimate naman si A, and hindi naman legitimate yung relationship niya with the lolo, which is C. So if it kills C, it's murder or homicide. Okay. So, next article is Article 247, death or physical injuries inflicted under exceptional circumstances. So the penalty here is either destierro or you'll be exempted. So the death or physical injuries, this is the provision. Any legally married person who, having surprised by his spouse in the act of committing sexual intercourse with another person, shall kill any of them or both of them in the act or immediately thereafter, or shall inflict upon them serious physical injuries, shall suffer the penalty of destierro. If he shall inflict upon them physical injuries of any other kind, he shall be exempt from punishment. These rules shall be applicable under the same circumstances to parents with respect to their daughters under 18 years of age and their seducer while the daughters are living with their parents. And any person who shall promote or facilitate the prostitution of his daughter or his wife shall otherwise have consented to the infidelity of the other spouse shall not be entitled to the benefits of this article. Para ako nag-rap, di ba? But of course, it's good to memorize provisions, but of course, we have to understand, we have to decipher them. So, ito na yun. Elements. That a legally married person or a parent surprises his spouse or his daughter, the latter under 18 years of age, so the daughter is under 18 years of age and living with him and in the act of committing sexual intercourse with another person. Number two, that the said legally married spouse, he or she kills any of them or both of them or inflicts upon any or both of them any serious physical injuries in the act immediately or thereafter. That he has not promoted or facilitated the prostitution of his wife or daughter, or that he or she has not consented to the infidelity of the other spouse. So, ito. There are two stages enumerated in this article. It says that first, when the offender surprised the other spouse with a paramour or mistress, the attack must take place while the sexual intercourse is ongoing. So, kailangan mahuli mo sila na ginagawa yon. If the surprise was before or after the intercourse, no matter how immediate in this situation, only gets the benefit. Immediate it may be. Article 247 does not apply. The offender in this situation only gets the benefit of the mitigating circumstance, that is sufficient provocation immediately preceding the act. Then the second stage enumerated in this is when the offender kills or inflicts serious physical injury upon the other spouse and or paramour while in the act of intercourse or immediately thereafter. That is after surprising pa rin. So you have to divide the stages because as far as the first stage is concerned, it does not admit to any situation less than sexual intercourse. So if the surprising took place before any actual sexual intercourse could be done, because the parties are only in their preliminary, so parang naguhubad pa lang sila, the article cannot be invoked anymore. Di ba? Nakakaloka. But anyway, if the surprising took place after the sexual intercourse or nagbibihis na sila, even if the act indicates that they indeed made the sexual intercourse, the article also does not apply. As long as the surprising took place while the sexual intercourse was ongoing. So, kailangan talaga mahuli mo sila na nagchuchok-tsakan. So, the second stage, with the sexual intercourse going on, the second stage becomes immaterial. It is either killing or inflicting physical injuries while in that act or immediately thereafter if the killing was done while in the act, no problem. Kasi nga, kailangan mo talaga silang mahuli paulit-ulit. Now, if the killing was done when the sexual intercourse is finished, a problem arises. So yung mga questions na, were they surprised in the actual sexual intercourse? Were they killed immediately thereafter? So parang nagkaka-doubts. But it automatically goes to this provision if nahuli mo nga sila while doing it. So what does the phrase immediately thereafter mean ba? So the Supreme Court said that immediately thereafter means there must not be a lapse of time between the surprising and the killing. So kailangan pag nahuli mo sila, talagang saksakin mo na sila agad, ganun. So yung therefore the surprising and the killing of or infliction of serious physical injuries, it must be a continuing process from the time na nahuli, inflicting serious physical injuries. It has to be from the same heat of anger. So if you caught them, tas bukas mo pa pinatay, it's not this article does not apply anymore. I'll give a problem, for example. What if the wife, arrived home from the wet market and she suddenly heard voices in the master's bedroom? And so she opened the said bedroom and saw her legal husband B in the act of sexual intercourse with C, another person. So the law says that other person kasi, which means that it could be a man and woman. So hindi siya encapsulated into if you caught your husband na it's automatically a woman. Other person, so let's say your husband is gay. So if you found him having sexual intercourse with another man, this article may still apply. So upon seeing that, A, who still has a knife in her tote bag, immediately went towards B and C. Sinaksak niya pareha sila. So B died, the husband died, then the kabet survived, C. So is A liable for parricide under Article 246? Parricide nga ba to? So here, no, she is liable under Article 247 or death under exceptional circumstances. The Supreme Court said that Article 247 is actually not a felony. Article 247 is a privilege. In fact, it's a defense. Article 247, pag na-invoke siya, the accused is free from criminal liability. So it's also said to be an absolutory cause, an exempting circumstance. The Supreme Court said that the penalty stated therein, discharge, is actually not a penalty. Pero para lang maprotektahan yung offender from resback dun sa family nung offended part or nung pinatay niya. So discharge is not really a penalty. The married spouse who killed the other spouse, it is not a penalty, but it is more of a guard, a privilege for him so that he may be free from any retaliation. As I said, baka resbakan siya. So this case, it's a very important case. It's actually a landmark case. You always have to remember this case kasi yun na nga, yung sinabi ko kanina na immediately thereafter, it applies in this case. So in this case, there was the student. Parang kami, law student, pero siya nag-review na siya sa bar, kami first year pa lang, char. So anyway, so this student was reviewing for the bar. There were already rumors na yung wife niya was having an affair. So one time, he went home unannounced. Then upon his arrival, he saw his wife having sexual intercourse with another man. Shook siya. Then the husband of course, he wanted to kill the man, but he had no weapon at that time. And I remember in this case, I think the man who was having his sexual intercourse with his wife had a weapon. That's why he didn't actually just jump in and punch the guy. So he saw na may weapon yon. So it took an hour for the husband to find the weapon. Humanap talaga siya ng weapon. And upon finding the weapon, he went directly to the whereabouts of the man. Apparently, tapos na magtsaktsakan yung dalawa. And parang nagsusugal na ata yung guy, I think. And there, the killing took place. So I think he got a rifle and he shot the guy. But he also injured like other people there. So, the killing took place an hour, not in the actual sexual intercourse. So, ito na nga yung immediately thereafter. Pero isang oras talagang immediate. Does it go under immediately thereafter? Despite the fact that hour has already elapsed, would it still be in the meaning of that? So, the Supreme Court said in this special case, yes, according to the Supreme Court, when the law uses the phrase immediately thereafter, that the killing or the infliction of serious physical injuries must take place immediately thereafter. That the law did not say that the killing must be done like instantly. So, yun na nga, yung parang sinasabi ko kanina, as long as the drive for killing is under the same impulse, which is in this case it's understandable, like he saw the guy having a weapon, so it took him 1 hour and he was really still mad an hour later, of course, when he caught his wife having sexual intercourse, and so the killing was done in the same impulse, so continuous siya, so pasok daw yan, sabi ng Supreme Court. It suffices that the proximate cause, remember from our Crime 1, proximate cause for the said killing is the said pain and the look on the said husband upon chancing his wife in the basest act of infidelity. So, sinabi nga na this is an exceptional case. So, why is it an exceptional case? Kasi dito, sinabi ng Supreme Court na immediately thereafter, kasi after this case, I think, sinabi ng Supreme Court na wala na dapat lapse ng time. So, parang sinabi lang na in this case, they just ruled because of the circumstances that surrounded the case. Also, parang legal luminaries were also saying na it's an exceptional case because the husband was reviewing for the bar, kaya siya binigyan ng parang special treatment or whatever. Pero but I think it's a really important case to remember because it really it provides for the meaning of immediately thereafter, and it also gave examples of what could transpire in cases that is falling under Article 247. So, with regard naman dun sa liability ni Abarca dun sa injuries that was sustained by the other parties, like I said a while ago, when he discharged the gun, he also injured other people other than the man he killed. So the Supreme Court said that that he's only liable for physical injuries through negligence, as the case may be, kasi nga wala namang intent to kill. So note that the Supreme Court ruled that inflicting death under exceptional circumstances is not murder. So the benefits of this article, dun sa paragraph 2 and 3, when it applies to the parents, di ba? When the parents caught their daughter, for example, yung batang, their daughter is less than 18 years of age and they caught her having sexual intercourse. Tapos yung guy, their seducer, is actually inside of their house, they could actually kill the man. So the benefits of this article do not apply to the person who consented to the infidelity of his spouse or who facilitated the prostitution of his wife. So kung yung guy is alam niya na nag-cheat yung wife niya, this article wouldn't apply. The article is also made available to the parents who shall surprise their daughter below 18 years of age, like I said a while ago, while living with them. So it's important to know that kailangan nandun yung bahay nila pa nakatira sa loob ng house. So basically kung kasal na, hindi naman, this won't apply. The act could have been committed by the daughter with the seducer. The two stages also apply. The parents cannot invoke this provision if in a way they have encouraged the prostitution of the daughter. So kung binugaw naman nila yung anak nila, this won't apply. So the phrase, as I said, living with them is understood to be in their dwelling because of the embarrassment and yung magiging parang driving force naman ng parents dito is yung embarrassment and humiliation done not only to the parent but also to the parental abode. So pag ginawa daw yung crime in the motel, this does not apply, strictly construing what the article says. Okay, we move now to murder. Article 248, murder. So the penalty is reclusion perpetua. Ang haba na naman, mag-rap na naman me. Murder. Any person who, not falling within the provisions of Article 246, Parricide, shall kill another, shall be guilty of murder, and shall be punished by reclusion temporal in its maximum period to death if committed by any of the following attendant circumstances. So, reclusion temporal to death. Range. 1, with treachery, abuse of superior strength, taking advantage of superior strength, the aid of armed man, employing means to weaken the defense or means to ensure or afford impunity, in consideration of price, reward, or promise, by means of inundation, fire, poison, explosions, shipwreck, stranding of a vessel, derailment upon a railroad, assault, assault upon a streetcar or locomotive, fall of an airship, by means of the use of any other means involving great waste or ruin. Number 4, on occasion of any of the calamities enumerated in the preceding paragraph, or of an earthquake, eruption of a volcano, destructive cyclone, epidemic, or any other public calamity. With number 5, with evident premeditation. Number 6, with cruelty, by deliberately and inhumanly augmenting and scoffing of the victim, or outraging or scoffing at his person or corpse. Okay, I guess niyo pa ba yun? But anyway, it's good to memorize these provisions because if it's stuck in your head, you just kind of just compartmentalize it. Pero okay lang naman din kung hindi, basta gets mo siya. Anyway, the elements of the crime: that the person was killed, that the accused killed him, that the killing was attended by any of the qualifying circumstances mentioned in Article 248, and that the killing is not parricide or infanticide. So, eto na nga, yung attendant circumstances. Most of these are found in Article 14, the aggravating circumstances, except the last one, yung with cruelty, by deliberately and inhumanly augmenting the suffering of the victim, or outraging or scoffing at his person or corpse. Basically, yung 1 to 5, you can find it from aggravating circumstances. So, these are the attendant circumstances. So, kung pumatay ka ng tao, tapos may treachery, pumatay ka, tapos may kapalit kasi na pera. So, pag pumatay ka, tapos, involved siya sa stranding of a vessel, derailment or assault upon a railroad, or kumari, nagka-earthquake, tapos may pinatay ka. Yan, these would qualify the crime from homicide to murder. So, these are the Supreme Court rulings to remember. The killing of a child of tender age is murder. Qualified by treachery because the weakness of the child due to his tender age results in the absence of any danger to the aggressor. So automatic yun. Kung pinatay mo is bata, tapos wala namang kalaban-laban, you can't really say that it's homicide. It's already murder. So second is evident premeditation is absorbed in price, reward, or promise. Kasi obvious naman na napag-isipan mo to ng mabuti. The inductor would not have induced the other to commit the act, but not as regard as the one induced. The third is abuse of superior strength is inherent in and comprehended by the circumstances of treachery or forms part of treachery. The fourth is treachery is inherent in poison. Then fifth is where one of the accused who were charged with murder was the wife was the wife of the deceased, but here relationship to the deceased was not alleged in the information. Kasi in Parricide, you should allege that it's parricide in the information. So if you weren't able to allege it, pwedeng maging murder siya. She also should be convicted of murder, but the relationship should be yun nga, aggravating na lang. And sixth, killing of the victims hit by hand grenade thrown at them is murder qualified by explosion and not treachery. So we go now sa problems, example problems. What if A and B hacked each other after bickering over online sabong? So usong-uso yung online sabong ngayon, lalo na pandemic. So may walang mga gathering, puro online lang. Pati sabong online na rin. Anyway, so A died as a consequence. What is the crime? So it is homicide. Kasi wala namang sinabi dun sa problem na it's attended by treachery, it's attended by it's in consideration of a price reward or promise, or may scoffing dun sa victim, ganyan. So wala naman kasi yung circumstance na inalleged dito. So the crime is homicide. So ito, in the same problem, what if B, hindi siya na-satisfy na pinatay lang niya si A? He dismembered his body and displayed his severed head in the gate. Kakaloka, diba? So chinop-chop niya, tapos yung ulo nilagay niya dun, display niya pa. So what is the crime in this case? The crime is already murder. This falls under the sixth attending circumstance. If the killer tried to dismember the different parts of the body of the victim indicative of an intention to scoff at or decry or humiliate the corpse of the victim, then that would have murder because this circumstance is recognized under Article 248, even though it was inflicted or was committed when the victim was already dead. So, kung murder siya at first or homicide siya at first, the moment na pinaglaruan mo yung body, yeah, it becomes murder. It qualifies to murder rather. So, we go now to the next article, homicide. So, the penalty is reclusion temporal. So, any person who, not falling within the provisions of Article 246, shall kill another without the attendance of any of the circumstances enumerated in the next preceding article shall be deemed guilty of homicide and be punished by reclusion temporal. So what are the elements of homicide? 1, that the person is killed. 2, that the accused killed him without any justifying circumstance. Yung justifying circumstance, those are the ones in Article 11 that pag na-justify yung killing, there's no crime. So 3rd, that the accused had the intention to kill, which is presumed. And 4th, that the killing was not attended by any of the aggravating circumstance of murder or by that of parricide or infanticide. So homicide is the unlawful killing of a person, not constituting murder, parricide, or infanticide. So ito yung simple killing na tinatawag. Like if you kill a person, tapos not attended by any of those enumerated kanina, it's considered homicide. So these are the Supreme Court rulings to remember. Number 1, physical injuries are included as one of the essential elements of frustrated homicide. Number 2, if the deceased received 2 wounds from 2 persons acting independently of each other and the wound inflicted by either could have caused death, both of them are liable for the death of the victim and each of them is guilty of homicide. Number 3, if the injuries were mortal but were only due to negligence, the crime committed will be serious physical injuries through reckless imprudence, as the element of intent to kill in frustrated homicide is incompatible with negligence or imprudence. Number 4, where the intent to kill is not manifest, the crime committed has been generally considered as physical injuries and not attempted or frustrated murder or homicide. Number 5, when several assailants not acting in conspiracy inflicted wounds on a victim, but it cannot be determined who inflicted which, would uh, uh in when for the belong anyway, which caused the death of the victim, are all liable for the victim's death. So note that while it is possible to have a crime of homicide through reckless imprudence, it is not possible to have a crime of frustrated homicide through reckless imprudence. So there's no such thing. You have to remember that. So, homicide versus physical injuries. In attempted or frustrated homicide, there is no intent to kill. In physical injuries, there is no intent to kill. However, if as a result of the physical injuries, the victim died, the crime will be homicide because the law punishes the result and not the intent of the act. So kahit na physical injuries lang siya at first, tas namatay yung person, it's still homicide. Basta mamatay yung person, it's homicide. So physical injuries, that's gonna be discussed in a whole other video. I hope I'll still be able to upload by then. We go now to Article 250. I didn't discuss this further. I'm just gonna discuss the provision. So penalty for frustrated parricide, murder, or homicide. As we all know, like Article 51 of the RPC discusses that persons, the principals that the principals, the accomplices, the accessories that committed frustrated or attempted stages of felonies, and therefore, in this case, their penalties becomes lower. So I'll just read the provision. The courts, in view of the fact of the case, may impose upon the person guilty of the frustrated crime of parricide, murder, or homicide, defined and penalized in the preceding articles, a penalty lower by 1 degree than that which should be imposed under the provisions of Article 50. The courts, considering the facts of the case, may likewise reduce by 1 degree the penalty which under Article 51 should be imposed for an attempt to commit any of such crimes. So yun na nga. It also it discusses frustrated or attempted parricide, murder, or homicide. So next is Article 251, death caused in a tumultuous affray. So ito, mahaba rin yung provision niya. While several persons not consisting groups organized for the common purpose of assaulting and attacking each other, assault and attack each other reciprocally in a confused and tumultuous manner, and in the course of the affray, a person is killed, and it cannot be ascertained who killed the deceased. If it can be identified who inflicted serious physical injuries, the penalty of prison mayor will be imposed. If it cannot be determined who inflicted serious physical injuries on the deceased, the penalty of prison correctional in its medium and maximum period shall be imposed upon all those who shall have used violence upon the victim. So tumultuous affray simply means commotion in a tumultuous and confused manner. So kaguluhan to, like magulong-magulo. To such an extent that it would not be possible to identify who the killer is if death results, or who inflicted the serious physical injury, but the person or persons who used violence are known. So ito yung parang may ramble, may ganyan, pero it can't be organized groups, it can't be, it can't be gangs against gangs, which I'll give in my examples later actually. So what are the elements? First, that there be several persons. Second, that they did not compose of groups organized for the common purpose of assaulting and attacking each other reciprocally. Third, that these several persons quarreled and assaulted one another in a confused and tumultuous manner. Fourth, that someone was killed in the course of the affray. Fifth, that it cannot be certain who actually killed the deceased. And sixth, that the person or persons who inflicted serious physical injuries or who used violence can be identified. So it is not the tumultuous affray which brings about the crime. It is the inability to ascertain the actual perpetrator. It is necessary that the very person who caused the death cannot be known, not that he cannot be identified. Because if he is known, but only his identity is not known, then he will be charged for the crime of homicide or murder under a fictitious name and not death in a tumultuous affray. If there is conspiracy, the crime is not committed. So, ito na nga, examples. What if a fight ensued between 10 kamote gang men, so kamote boys, and 10 busy boys, so they're also a gang, and in the course thereof, one of each, so isa sa mga tao nila napatay, both groups. Is the crime committed under Article 251? So, no, because the crime would be homicide or murder. There will be collective responsibility on both sides, since gangs are groups that are organized to assault and attack each other. But as long as it cannot be determined who killed the victim, although all of those persons who inflicted serious physical injuries will be collectively answerable for the death of that fellow, the fight must be tumultuous, and the participants must not be members of an organized group. So in this case, yun na nga. Since organized group sila for kaguluhan, it can't. So the second, what if A and B were dancing in their JS prom and suddenly XYZ attacked B because of jealousy, and in turn C and D, A's companions joined the fight. So ito, kaguluhan din sila. In the course of the fight, A died and C saw that si Z, was the one who shot A, so he had a gun. Is this death caused in a tumultuous affray? So still, no. The crime committed is murder or homicide, as the case may be, since it can be identified who killed the deceased. Since kayang i-identify ni C na si Z yung pumatay kay A, so hindi pa rin mag-a-apply to kahit na nagkaguluhan sila. And hindi naman sila organized groups. So here, someone is killed. Note that he can be any person. Kahit na kung wari, it's JS prom, kahit na ibang person yung namatay in the course of the kaguluhan, tapos hindi nila talaga ma-identify who was the one who had the gun or had a knife, it can fall under this article. So he can be a mere passerby, just watching the affray, so long as he's killed in the affray and it cannot be ascertained who killed him. Then the person who inflicted serious physical injury on him is liable if he can be identified. Then the person who used any kind of violence against him is also criminally liable. So yung may ibang cases dito na nabasa ko, I think it's Season? Yeah, Season versus People. It's the time of the Marcos era, and I think Cory was just it was the time of the Freedom Constitution. Anyway, so yun yung time na kakatapos lang ng EDSA, and Cory was already the president. So there was this so-called Marcos loyalists, ganyan, tapos may mga Coryistas, and parang this group of mga nagrally, they ganged up on one person who was a Coryist. They identified as a Coryist. So, ayun, parang hinabol nila all throughout Rojas Boulevard. Like, parang binubugbog lang nila and all. And they were saying that it was under tumultuous affray kasi nga may rally beforehand. So, the court ruled there na hindi. Kasi, the people who actually ganged up on that certain person can be actually identified kahit na marami sila and kahit na nagkaguluhan sila. Imagine naman kung nangyari yun at this time, yung mga DDS. Char. But anyway, on to the next slide. So it's just another article, Article 252, physical injuries inflicted upon in a tumultuous affray. When in a tumultuous affray, as referred to in the preceding article, only serious physical injuries are inflicted upon the participants thereof, and the person responsible thereof cannot be identified. All those persons who appear to have used violence upon the person of the offended party shall suffer the penalty next lower in degree than that provided for the physical injury so inflicted. When the physical injuries inflicted are of a less serious nature and the person responsible thereof cannot be identified, all those who appear to have used any violence upon the person of the offended party shall be punished by arrest and mayor from 5 to 15 days. So this basically just expands the understanding of physical injuries that are caused in the tumultuous affray. So we go now to Article 253, giving assistance to suicide. So are people liable for this? the provision says that any person who shall assist another to commit suicide shall suffer the penalty of prison major. If such person leads his assistance to another to the extent of doing the killing himself, he shall suffer the penalty of reclusion temporal. However, if the suicide is not consummated, the penalty of arresto mayor in its medium and maximum periods shall be imposed. What are the acts punished here? Assisting another to commit suicide, whether the suicide is consummated or not, then lending his assistance to another to commit suicide to the extent of doing the killing himself. So giving assistance to suicide means kung bigyan mo siya ng lason, bigyan mo siya ng rope, ganyan, or whatever manner of positive and direct cooperation. So kung talagang pinush mo siya na in-encourage mo siya na mag-suicide na siya, mamatay na siya, ganyan, kakaloka. Anyway, in this crime, the intention must be for the person who is asking the assistance of another to commit suicide. If the intention is not to commit suicide, as when he just wanted to have a picture taken of him upon the impression upon the world that he is committing suicide because he is not satisfied with the government, for example, the crime is held to be inciting to sedition. He becomes a co-conspirator in the crime of inciting to sedition, but not of giving assistance to suicide, because the assistance must be given to one who is really determined to commit suicide. So you have to remember this. If the person does the killing himself, the penalty is similar to that of homicide, which is reclusion temporal. There can be no qualifying circumstance because the determination to die must come from the victim, yung gustong mamatay. This does not contemplate euthanasia or mercy killing where the crime is homicide. So, magbibigay ako ng examples to further understand what is this article all about. So here, B wanted to commit suicide. So ito si A gave assistance to B. But si B nakaligtas. B did not die. So parehas ba silang criminally liable? Excuse me. So here, no, only A is criminally liable because suicide or attempt to commit suicide is not a felony within the Philippine jurisdiction. Parang sinasabi pa nga dun sa book na yung they find the person who wants to die pitiful and like that, parang nakakaawa siya and all. So he's not criminally liable. But yung nag-assist sa kanya is criminally liable under this article. Gets ba? So next example. What if A had cancer? He has been lying in the bed he has been lying in the bed almost lifeless, and it was only a machine that's giving life to his body now. So the mother of A, B, took pity of her son and wanted to finish the suffering of A kasi nga sa machine na lang nabubuhay yung anak niya. And so when she visited one time, she turned off the machine and the son died. He killed her son out of mercy, sabi niya. So it's mercy killing or euthanasia nga. Is the mother liable for giving assistance to suicide? Is she liable under Article 253? So the court ruled that no, because the initiative to kill did not come from the said person who was ill. Typo again. So the crime committed by the mother is parricide for killing her son. Kasi evidently kasi yung kailangan may intention, yung gustuhin ng anak na mamatay na siya. So pag euthanasia siya, it's gonna be parricide. Pag ibang tao yung pinatay ng mom, for example, hindi niya anak yon, it's gonna be murder because there was evident premeditation, hindi siya pwedeng homicide. So pag pinatay mo yung taong ganun in this manner, tapos hindi falling within the provisions of parricide, it's considered murder. So we go now to Article 254, Discharge of Firearms. So discharge of firearms. Any person who shall shoot at another with any firearm shall suffer the penalty of prison correctional in its minimum and medium periods unless the facts of the case are such that the act be committed, that the act can be held to constitute frustrated or attempted parricide, murder, or homicide, or any other crime for which a higher penalty is prescribed by any of the other articles in this code. What are the elements of this crime? That the offender discharges a firearm against or at another person. Number 2, that the offender has no intention to kill that person. So nakapag-discharge siya ng firearm pero wala naman siyang gustong patayin. Let's give an example. What if A was in Luneta on a Saturday? So, daming tao nun kasi hindi pa COVID, for example, that time. Then, A, papansin siya, shots in the air using his firearm. Is this discharge of firearms under Article 254? So, no. A committed alarms and scandals under Article 155. When he fired shots in the air, his intention was to cause disturbance of public peace and tranquility. The firearm was not aimed at any person. So another example would be, what if A and B quarreled over a game of pusoy last Tuesday? Then on Friday, when A saw B, he poked his gun at B. So what crime is committed? So ano lang naman to, sa sugalan na naman. The crime committed is other life threats. So hindi pa rin siya under this article. The threatening of another with a gun without discharging, pag pinupoke mo lang siya dun sa tao, it is other life threat. It is not grave threats. It is not light threats. It's other life threats. So kapag dinischarge, pag pinutok, it can be either alarms and other scandals, illegal discharge of firearms, or attempted or frustrated murder or homicide, as the case may be. Pag hindi pinutok, only pinoke lang, that sounds so weird. Anyway, or threatening with a firearm, it is only other life threats. So, remember, pag pinutok, hindi pinutok, charot. So, this case, actually, pag yung article na yan, I immediately remember this case because ito lang yung case na nag-apply yung Article 254. So, in this case, there were policemen and they were operating in a mission. Parang set-up mission siya. And there were 4 men. They were policemen and they saw one guy approaching. Akala nila yun na yung kailangan nilang i-apprehend. So they discharged the firearm. But apparently, it was the nephew of one of the 4 policemen. So, yung nag-discharge ng firearm, si Eraso, pareha silang na-accuse of homicide. Pero si Eraso, siya kasi yung unang bumaril. Tapos, yung pangalawa, parang he just discharged his firearms on the act of the other. Parang impulsively lang. Tapos, I think he just described it on his side or something like that. In the case at bar, petitioner and accuser, as seemingly concerted and almost simultaneous, kasi nga sabay, were more of a spontaneous reaction rather than a result of a common plan to kill the victim. Simultaneity alone would not be enough to demonstrate the concurrence of will or the unity of action and purpose that could be the basis of collective responsibility. Kasi sinabi nga na they conspired to kill of 2 or more individuals, particularly as in the case at bar, the incident occurred at the spur of the moment. So, wala naman talagang intent to kill on the part of Dado. So, absent an intent to kill in firing the gun towards the victim, petitioner should be held liable for reasonable doubt. Crime of illegal firearms kasi nga, all the elements were present. That yung si Dado nag-discharge ng firearm kasi nag-discharge si Eraso kasi nga akala nila yun na yung person against another person and that the offender has no intention to kill that person. Though the information charge against the petitioner was murder, it was actually murder at first. He could be validly convicted of illegal discharge of firearm, an offense which is necessarily included in the crime of unlawfully killing a person. So Eraso was still charged with homicide in this case. So, ayun na nga. So, si Dado, siya yung na-charge ng Article 254. Okay ba? So that ends my discussion on the first part of Title 8, Crimes Against Persons. I will continue uploading videos for I will continue uploading videos for part 2, part 3 if I'm gonna need a part 3, and for the other titles of RPC, book 2 of the revised penal code. So thank you for listening, and I hope this video actually helped in your review. 안녕.